The European Court of Human Rights, also known as the Strasbourg Court, is an international court of the Council of Europe which interprets the European Convention on Human Rights. The court hears applications alleging that a contracting state has breached one or more of the human rights enumerated in the Convention or its optional protocols to which a member state is a party. The European Convention on Human Rights is also referred to by the initials, ECHR. The court is based in Strasbourg, France. An application can be lodged by an individual, a group of individuals, or one or more of the other contracting states. Aside from judgments, the court can also issue advisory opinions. The convention was adopted within the context of the Council of Europe, and all of its 47 member states are contracting parties to the convention. The court's primary means of judicial interpretation is the living instrument doctrine, meaning that the convention is interpreted in light of present-day conditions. International law scholars consider the ECTHR to be the most effective international human rights court in the world. Nevertheless, the court has faced challenges with verdicts not implemented by the contracting parties, as well as balancing caseload management with access. On the 10th of December 1948, the United Nations adopted the Universal Declaration of Human Rights, which aims to promote the universal recognition of rights set out therein, in order to strengthen the protection of human rights at the international level. On the 5th of May 1949, the Council of Europe was created in London. The members of the Council consider that the UN Declaration seeks to ensure the universal and effective recognition and application of the rights set forth therein. The court was established on the 21st of January 1959 on the basis of Article 19 of the European Convention on Human Rights, when its first members were elected by the Parliamentary Assembly of the Council of Europe. Initially, access to the court was restricted by the European Commission of Human Rights. Abolished in 1998, the court kept a low profile during its first years and did not accumulate much case law, first finding a violation in Neumeister v. Austria. The convention charges the court with ensuring the observance of the engagement undertaken by the contracting states in relation to the convention and its protocols, that is, ensuring the enforcement and implementation of the European Convention in the member states of the Council of Europe. The European Court of Human Rights, which enforces the European Convention on Human Rights, is the best-known body of the Council of Europe. The Council of Europe is an international organization founded in the wake of World War II to uphold human rights, democracy and the rule of law in Europe. Founded in 1949, it has 47 member states, with a population of approximately 820 million, and operates with an annual budget of approximately 500 million euros. The organization is distinct from the 27-nation European Union, although it is sometimes confused with it, partly because the EU has adopted the original European flag, which was created by the Council of Europe in 1955, as well as the European anthem. No country has ever joined the EU without first belonging to the Council of Europe. The Council of Europe is an official United Nations observer. The jurisdiction of the court has been recognized to date by all 47 member states of the Council of Europe. On the 1st of November 1998, the court became a full-time institution, and the European Commission of Human Rights, which used to decide on admissibility of applications, was abolished by Protocol 11. The accession of new states to the European Convention on Human Rights following the fall of the Berlin Wall in 1989 led to a sharp increase in applications filed in the court. The efficiency of the court was threatened seriously by the large accumulation of pending applications. In 1999, 8,400 applications were allocated to be heard. In 2003, 27,200 cases were filed and the number pending rose to approximately 65,000. In 2005, the court opened 45,500 case files. In 2009, 57,200 applications were allocated, with 119,300 pending. At the time, more than 90% of applications were declared to be inadmissible, and the majority of cases decided, around 60% of the decisions by the court, related to what is termed repetitive cases, where the court has already delivered judgment finding a violation of the European Convention on Human rights are where well-established case law exists on a similar case. Protocol 11 was designed to deal with the backlog of pending cases by establishing the court and its judges as a full-time institution, by simplifying the procedure and reducing the length of proceedings. However, as the workload of the court continued to increase, the contracting states agreed that further reforms were necessary, and in May 2004, the Council of Europe Committee of Ministers adopted Protocol 14 to the